thank you all very, very much for attending on what for most of us is a really sweltering day. So we're going to talk about where we're now and where we're going. And its overarching objective was to provide companies with the flexibility to continue trading during and after COVID. And really it did this with a mixture of temporary easements to the insolvency law, and that was coupled with 3 permanent measures to help companies recover as the economy re-emerged and really for the longer term. Now, the permanent measures were the restructuring plan under Part 26A of the Companies Act, the standalone moratorium under Part A1 of the Insolvency Act, and the restriction on contractual termination, otherwise known as Ipso facto clauses under Section 233B of the Insolvency Act. As regards these permanent measures, the government committed to review them within 3 years of CIGA coming into force. And that review's been divided into 2 stages. The first stage involved commissioning the University of Wolverhampton in September 2021 to conduct independent research via in-depth interviews with IPs, legal professionals and trade associations. And based on that research, the Insolvency Service published on the 21st of June 2022 the interim report, CIGA, which collated the data gathered by the university team with their interpretation of it in order to provide conclusions in relation to the main research questions. The report itself, however, doesn't make any recommendations. As part of stage 2, the research team will do an online survey with IPs and conduct further interviews. The Insolvency Service will then consider the evidence in the current interim report and the report for stage 2 in its review, which is due in June 2023, will consider if refinements or changes need to be made. Now, looking at the interim report itself and based on the evidence from the research carried out, the report reaches really the following conclusions. First of all, as regards restructuring plans, the positives were that these plans were seen as a success, really building on existing case law in governing schemes. The cross-class cram-down power has been used successfully in cases where previously a scheme on its own would not have been effective. The high quality of judges adjudicating on restructuring plans are also seen as a real strength of the restructuring plan. Further research has actually shown that successful restructuring plans appear to have resulted in job losses being avoided. The negatives are that restructuring plans are seen as too costly and too time-consuming for use in the SME market, and the cost really for a straightforward SME being around £100,000 to £150,000. And that's really compared to the typical cost for a CVA, which is between £25,000 and £35,000. It was also felt that in simpler cases, courts and stakeholders could be more pragmatic about the required documentation, and really that the matter could be dealt with in a single hearing by an ICC judge. The research also showed that the costs of challenging a restructuring plan were excessive, and that this hinders the policy objective of protecting dissenting creditors. There was also a perceived problem with creditors having adequate access to information, and without greater disclosure and transparency requirements, it was felt that the envisaged protection of creditors will be diminished. Finally, it was concluded that the primary legislation governing restructuring plans might be made more attractive when compared with overseas jurisdictions. So far as the moratorium is concerned, the positives were that it had been used successfully and had satisfied policy objectives, including provided greater opportunities for company survival and giving companies a breathing space to consider a plan for rescue as a going concern. It was also considered that the costs of the moratorium were reasonable. Interestingly, the measure is currently seen as being suitable for SMEs, but was not really being used by larger companies. And on the negative side, there were significant concerns that it alters pre-existing priorities in any subsequent insolvency. It was felt that this alteration of creditor priorities might have unintended consequences. Uncertainty was also expressed about how the alteration of priorities operated in relation to a number of specific types of creditor, in particular where there were hire purchase and conditional sale agreements. Finally, as to the restrictions for ipso facto clauses, these are seen as a positive addition to the powers available to IPs and companies who have entered into formal insolvency procedure. The measure is seen to satisfy its policy objectives, but the report concluded that it was too early to assess finally how this measure would operate, and that's partly because of the other temporary measures that governed during the pandemic. So now let's go to our speakers. We've got our two speakers today. First of all, welcome to Katie. Katie does insolvency and commercial work for both international and domestic clients and has notable expertise in cross-border insolvency matters. She's been consistently ranked in both Chambers and Partners and Legal 500, Legal 500 describing her as a rising star. And James, he's been a tenant now regular for about a year and a half. And before coming to the bar, he trained and practiced as a solicitor in the litigation department of a leading US firm, and both in the London and Hong Kong office, where he advised clients on a variety of commercial disputes with international dimensions. Between 2017 and 18, he was a judicial assistant to Lord Hughes and Lady Black at the Supreme Court. James also practices in an insolvency and commercial law. So I'll take you over to Katie. Thank you.
Thank you, Tina. I think perhaps if we deal with one question first, which is obviously the uptake of restructuring plans.
Yes.
Obviously, it's been noted that between the 26th of June 2020 and the 30th of June this year, only 12 companies have had a restructuring plan registered at Companies House. And this is obviously less than hoped. The interim report notes that plans, as you've noted, Tina, are too costly and time consuming for use in the SME market. So the questions that arise from that is this the key obstacle? Are costs the key issue? And do we think that the uptake will improve? Now, certainly, I think so far as SMEs are concerned, costs are a major obstacle. And particularly also for creditors and members who would wish to otherwise challenge a plan. Some estimate that on average plans at the top end of the market can cost in the region of £2 to £10 million. Now, of course, we've got the case of Reamicus Finance, which was the first and only mid-market company to use the Part 26A procedure, certainly the only reported decision we have. And in that case, the costs of the challenger were just around the 165,000 mark, and it's understood that the costs of the plan company were also anticipated to be fairly low. But whilst that would seem to be quite a positive step, it seems to me that it might be seen as an anomaly, because what we also know is the companies who have used the scheme really have, the majority of them have their revenues in the hundreds of millions. And if you're looking at the companies such as ED&F Man and Virgin Active, we're looking at the revenues being in the billions. So the question then that flows from that is, why are these procedures seen as so costly? Well, first of all, the hearings are lengthy. With restructuring plans, you need to have, first of all, a convening hearing. So that's the hearing at which the court will determine the voting classes, and if there's any application on the part of the company to exclude a class, on the basis that they have no genuine economic interest. That will be determined at that stage as well. And in some cases, these convening hearings have been listed for 2 days. Then you have the sanction hearing, and in some cases, we've seen those being listed for 4 days. And at this hearing, the court has to consider, obviously, the plan, any issues that were not decided at the convening hearing stage, any cram down application, and of course, various factors which the court will need to take into account when it's exercising its discretion whether to approve the plan or not. In addition to this, we have seen in all of the reported decisions so far that junior and senior counsel have been instructed, and in some cases 3 barristers have been instructed on either side. And of course, you'll have sophisticated legal teams preparing the explanatory statements and the plans, and in most cases, we're seeing substantial bundles being filed as well. So that's why we're looking at a fairly costly procedure. So the question then that flows from that is, how do we reduce costs? The interim report notes that at the moment, plans have to be listed before a High Court judge. That's required by the practice statements, but it could be that these plans are to be listed before an ICC judge. Now, I just query here, it's difficult to see how that in and of itself would reduce costs. In some cases, the convening hearing could be dealt with on paper, but of course that's going to be wholly inappropriate for those cases where an application under section 901C4 is made, so an application where a class is said not to have a genuine economic interest. Another option is when one's putting together the plan documentation, is to use the a CVA kind of precedent rather than follow the scheme documentation. I know that Mr. Justice Zaccaroli thought this was a good idea as well, and it certainly seems to be a sensible one. I'd simply query that the courts have been emphatic that detailed information needs to be provided. Certainly that was emphasised in the Virgin Active case. So I query there how easy it will be to consolidate documentation. And I think in some ways the costs will reduce as professionals become more familiar with the area. And this reduction in cost may in and of itself increase the uptake of plans, but whether the familiarity in and of itself will be a significant cost reducing factor is to be seen. So in my view, it's difficult to see plans becoming commonplace in the SME market, and certainly that's what the report thought as well. It seems that for SMEs, CVAs are likely to be more attractive, but of course then CVAs can be a false economy, because of course you can challenge a CVA on grounds of material irregularity, unfair prejudice, or on jurisdiction grounds, whereas with a plan, you effectively front load those aspects of challenge. So at the convening hearing, you can apply to exclude a member or creditor class on grounds that they don't have an economic interest, or at the sanction hearing, seek to cram down any dissenting creditor. It seems to me that Part 26 schemes are still a good option for solvent companies. So those companies where the financial distress threshold is not satisfied. It's worth noting that for schemes, the courts can still exclude classes of creditors or members as a matter of common law, but of course this is codified for plans under section 901C4. But I think for generally for those companies who are suffering financial distress, Part 26A plans will be more attractive, and that's the reason. There's twofold. Firstly, there's no added burden of the numerosity requirement that you have with schemes, and secondly, you obviously have the benefit of the cross-class cram down provision. So that's how I see things going forward, Tina.
Thank you, Katie. And what message do you think the introduction of restructuring plans sends to the international market in a post-Brexit world?
Well, I think really 2 clear messages are put forward. Firstly, that we're open for business. The courts clearly have approved several plans with a significant international element. And secondly, that certainly in this context, that the jurisdiction is very pro-debtor. If I can just elaborate on the point of us being a pro-debtor jurisdiction here. So far, the reported judgment suggests that the court has only the courts have only refused to sanction one proposed plan. So that was the case that many of us will be familiar with, the Hurricane Energy case. Now that was a cross-class cram-down case, and in my view, it was always going to be difficult to persuade a court to exercise its discretion to approve that plan. And certainly it was always going to be difficult for the court to be satisfied that the relevant dissenting members were not going to be worse off. In that case, the relevant alternative was not immediate insolvency. In fact, the company was found to most likely trade profitably in the short term, so at least for 1 year, if not sanctioned. And the relevant alternative itself that was proposed was predicated on the directors having said to, or expected to, breach their duties. And of course, the court wasn't keen to assume that the directors would breach their statutory duties. And what the plan itself proposed was for shareholders to give up 95% of its equity, of their equity, immediately, compared to retaining 100% in a company that continued to trade. So whilst this plan has been refused, again, I think it needs to be seen somewhat in isolation. And if any lesson is to be learned from that case, is that don't prepare your plan too early. Another reason why I'd say that we're a fairly pro-debtor jurisdiction, certainly in this context, is that it's been identified that there is a significant evidential and financial burden on dissenting creditors or members if they wish to challenge valuation evidence put forward by the company. So they may wish to do this on an application that the class doesn't have a genuine economic interest, or that the relevant class should be crammed down. And in the Smile Telecoms litigation, Lord Justice Snowden has said that if a certain class wishes to challenge valuation evidence in this context, they'll need to do three things. Firstly, they'll need to obtain financial evidence from the company, so financial information to prove what point they're seeking to make. And if this information isn't provided voluntarily, they'll need to make their own application for disclosure. The second point is that they will need to put forward expert evidence, and this involves procuring a joint report and also tendering the expert for cross-examination. And then thirdly, obviously, the challenging creditor or member will need to attend the hearing and make their case there. So clearly there's going to be a high financial burden on those creditors and members. It's worth noting, though, that in that litigation, the applications weren't properly opposed. So evidence hadn't been filed. The creditor bank hadn't attended and sought to challenge the position of the plan company by correspondence. So obviously that didn't impress the judge very much. And as a result, this may have informed the Lord Justice's decision to introduce such a high burden. I'd also say that the judicial commentary in the judgments that we've seen identifies that we're fairly pro-debtor as well in this area. In the decision of ED&F Man Holdings, in the sanction hearing judgment, Mr. Justice Trower identified that it's likely that company directors are going to be in the best place to ascertain what the relevant alternative is. Again, query whether that's always going to be the case. And similarly, in the Smile Telecoms litigation, again, Lord Justice Snowden identified that in cases where the plan documentation is of fearsome complexity, such that the court doesn't have an opportunity to digest that information in depth, there will be some deference shown to the fact that the plan documentation has been prepared by a sophisticated law firm. Just one last thing I'd say on this point, Tina, is I think it's also worth noting that in the context of plans generally, the general cost rules don't apply. Now, it might be different for isolated applications, but so this means that if a member or creditor class makes an application or is opposing one and within a plan and decides that, and the court decides that they've assisted the court, but they're ultimately unsuccessful, the court could still decide that they should have some of their costs paid by the company. So that could be some incentive for members and creditors to challenge these plans, but of course cost orders aren't guaranteed, and I'd simply flag that a speculative cost order in favour of a dissenting creditor or member is unlikely to be enough incentive in and of itself to challenge a plan if it's already quite difficult for them financially.
So you made the point that we're open for business. How do courts approach plans that affect sort of for foreign companies or which affect foreign companies?
I'd say firstly, the courts have made it plain that they can sanction a plan for an overseas company. So we've seen that in the Smile Telecoms litigation. In that case, the company was incorporated in Mauritius. And similarly, the court can approve a plan where the company's an English company, but where it primarily affects foreign stakeholders. And it's worth just noting two examples. So the case of Gate Group Guarantee Limited, where the company was actually incorporated in this jurisdiction for the purpose of benefiting from the Part 26A scheme. And similarly, ED&F Man Holdings, where it was quite clear that the plan, for it to be effective, would need to work in the US and Brazil. As to approach, the international element really is addressed at two stages in the hearings. Firstly, the court will consider whether it has jurisdiction in the international sense, and secondly, we'll consider whether or how the international element is relevant when it's exercising its discretion to approve the plan or not. So that is a question of, will the plan be effective abroad? Now, if I just turn to the jurisdiction test first, it's fairly simple. First question to ask is if the company is liable to be wound up under the Insolvency Act. Of course, the court does have jurisdiction to wind up companies not registered in this jurisdiction. And then the question that follows on from that is there a sufficient connection with England and Wales? So in the Smile Telecoms litigation, the court found that there was, because the company's COMI was based within this jurisdiction, and also the relevant debt was governed by English law. Now, other factors which will be relevant in determining whether there is a sufficient connection will, of course, be whether the company has an establishment here, if it doesn't have its COMI here, or whether there are any assets located in this jurisdiction. When does the court consider the issue of jurisdiction in this context? Well, at the convening hearing, the court needs to consider if there's any obvious roadblock to the issue of jurisdiction. So it doesn't decide it substantively at that stage, but certainly it is a matter for the court to consider. And then when we move on to the sanction hearing, the court will determine the issue properly. Turning then to the relevance of the international element to the question of discretion, so whether the company will sanction the plan or not. In the Smile Telecoms litigation, Lord Justice Snowden identified three areas that the court needs to consider in this regard. Firstly, we need to question whether it's appropriate to sanction the plan affecting an overseas company or affecting overseas stakeholders. Now, this, of course, is going to be fact sensitive. The court will consider what is the plan actually doing. So is it seeking to alter the constitution? Is it seeking to increase share capital? Is it seeking to do something further, for instance, amend the shareholders' rights under whatever applicable agreements are in force? It may also consider at this stage whether there's a parallel scheme in the overseas jurisdiction. Then the second question is whether the plan is likely to achieve the result it intends. So this focuses around the mechanism that is put forward. So what we see often with plans and schemes is that they confer a power of attorney on the company so that the relevant elements of the plan can be introduced and implemented abroad. So the question then that leads on from that is, will that work? And for the plan company to satisfy the court that it will work, it needs to evidence this by way of expert evidence, because it will be a question of foreign law. And then the final question is, will the plan be effective overseas? So this is a question of recognition. And the test that applies here is a reasonable prospect test. So the court will need to be satisfied that there is a reasonable prospect that the plan will be recognised in the necessary foreign jurisdictions. So questions that may arise there are, has the foreign country implemented the model law? For instance, obviously we've got the cross-border regulations here. Will the relevant jurisdiction recognise this plan by virtue of its own domestic laws? And of course, these are all questions, again, which are going to be determined by virtue of the applicable foreign law in question. So what the plan company will need to do is proffer expert evidence, which is CPR compliant. And it's worth just flagging how crucial this is, because the courts will tend to defer to a well-prepared CPR compliant report, certainly absent evidence to the contrary. So in summary, my view is that this clear guidance from eminent judges does make plans more inviting to the international market, which is obviously certainly a helpful thing. And that's why I say we are very much open for business.
Thank you very much, Katie. It looks as though the future's bright for restructuring plans for really non-SMEs at the moment, and for those cases with an international element. So let's now turn to moratoriums. James, so let's have a look at the moratorium first. So between the 26th of June 2020 and the 30th of June 2022, in England and Wales, 39 moratoriums have taken place. So there appears to be a slightly larger number of these than the restructuring plans, but still there's really quite a slow uptake. And this is despite the interim report noting that those who have used the process actually welcome it. Why do you actually think this might be the case?
Thank you, Tina. So I think there's three main reasons overall that we're seeing a slower uptake in relation to the moratorium. The first one of these is just an overall lack of familiarity with this measure. The permanent measures in respect of the moratorium, they've only been in place since late last year. Of course, there was the variety of temporary restrictions on various insolvency proceedings and measures in relation to the coronavirus pandemic that only have begun to lift really in the past sort of 8 to 12 months. And so I think that's definitely put the brakes on people using them. You might have expected as well to see some usage of it in Northern Ireland, but in fact their rules are in abeyance because of the failure to approve the permanent measures before the Northern Ireland executive was suspended in February 2022, and the failure to form an executive following the May 2022 elections. So their temporary measures lapsed on the 30th of March this year. So there's an entire sort of jurisdiction within the UK that isn't even using these measures at the moment. So I think that's the first reason, a lack of familiarity and perhaps not the full uptake across the country. Secondly, as I think you mentioned in your introduction, and as the interim report indeed notes, there's a general assumption by companies, practitioners, lawyers, that the moratorium itself isn't intended to be used by larger companies, that it's more suited for much smaller entities, SMEs, and the like. I think there's, again, three reasons that's causing that, and perhaps four. So the first is exempted companies. There's a variety of company types that are exempted, and one of the most notable is those who have capital market arrangements of £10 million or more, and that's under Schedule ZA1 to the Insolvency Act. So already there's a large class of institutions which may have sort of large financing arrangements in the capital markets that are immediately ruled out of using the moratorium. So already you're looking at much smaller companies. The second reason is the exempted debts element. So there's a wide range and class of exempt contracts to which the moratorium does not apply. That includes lending contracts, factoring contracts, financial leasing, guarantee contracts, and derivatives. So while the moratorium is in place, those types of contracts still have to be serviced. The debt still must be paid for the moratorium to remain in place. So where companies have obviously large issues with their lenders or other financial contracts, the moratorium begins to look much less inviting to use. And thirdly, I think the moratorium looks better for smaller companies with trade creditors or landlords, because again, it creates this payment holiday, but only in respect of the non-exempt contracts. So really, what the focus is those smaller companies that maybe be engaged in sort of goods and services trade on a small scale, rather than have a requirement to either work within the financial markets or indeed require large-scale financial support. But that being said, it might be said that being able to put the brakes on your smaller trade creditors using the moratorium might give you renegotiation space with your financial lenders. So that's, I think, one of the reasons why it's better for smaller companies versus those larger companies, which of course will impact the uptake. And I think the third reason is, in fact, the role of the IP in the moratorium is very narrow. This is what's termed the monitor under Part 1A. Their role is very narrow. There's not much guidance in the statute as to what they're supposed to do and how they're supposed to do it. And coupled with that, the period of the moratorium is very short. It's 20 days, and it can't be extended much more than that without creditor or court consent. So what the monitor is there to do is obviously create this statement as to the likelihood of rescue of the company as a going concern. It's really there to assess company rescuability and whether the purposes of the moratorium are being fulfilled by, as you might guess it, monitoring the financial status of the company. And the reason this is in place, of course, is to keep costs low. The estimate for the cost of involving a monitor and bringing in the moratorium is it's designed to be in the region of £40,000 to £60,000. So a little bit more expensive than your CVA, but obviously much cheaper than a restructuring plan, but again, much more limited in what it actually does. And in terms of those extensions, what we're looking at is an initial period of 20 days. The company can extend that by a further 20 days. If they get creditor consent, they can extend up to a year in total. Or there's the slightly wider extension by the court, by whatever it decides is appropriate in its discretion. And there doesn't appear to be any real bar as to how long the court will be, but I don't think we can expect the courts to give these open-ended extensions, not least because we're dealing with a insolvency procedure that does have a payment holiday, and so may have a wider impact on other companies. And so I think on balance, looking at those three reasons as to why there hasn't been so much uptake, what we're looking is really a light touch breathing space mechanism rather than a more hands-on restructuring process like you might see under the other insolvency procedures available to companies seeking a rescue or a restructuring under the Insolvency Act. And so while there's enforcement protection from lenders and qualifying charge holders, there's no payment holiday in relation to them. And of course, the other big problem that causes is there's a risk of triggering default clauses in financial contracts, accelerating the debts under them, which will aggravate any distress the company's under, and may in fact render the moratorium procedure pointless, because in light of the acceleration provision, a monitor might say, well, I'm sorry, but this company is no longer able to pay its debts and I'm terminating it early. And I think it's interesting about the introduction of this sort of payment holiday coupled with an independent IP to monitor to some other jurisdictions, such as the examiner procedure in Ireland under their Companies Act 2014, which is designed to cater to a wider range of companies. So that's another debtor in possession procedure. So the management stays in place while there's a 100-day stay on enforcement, simply to allow a company to seek investment, whether to go for a scheme of arrangement, to carry out the various member and creditor meetings and reporting obligations. And how that works is you have an independent practitioner operating under high court supervision that crucially doesn't displace directors and management. And it's a system that can be used for a variety of companies, including large telecommunications companies or airlines such as CityJet. And alongside the large version, there's an examinership light version under their version of our county courts that is applicable to smaller companies with lower balance sheet numbers, turnover and employee number thresholds. So I think when we look at countries like Ireland, what they have in terms of their independent practitioner debtor in possession procedures, I think we can describe Part 1A moratoriums as a little bit of a missed opportunity. Sure, it gives this payment holiday, which on the face of it seems great for a company in distress. But obviously, they're going to need a lot more involvement with their financial lenders or other financial institutions whom they may have contracts with. It's not a one-size-fits-all regime. It really only does work for those smaller companies. And so the utility for larger companies or companies with, I think, much larger levels of distress is probably fairly low. And that's why we're just not seeing that uptake.
Right, so you've mentioned a lack of familiarity with the procedure and also highlighted the narrow scope of the monitor role. Have the courts had occasion to actually grapple with the moratorium?
Yes, there's been one decision on the moratorium, and it was handed down by the High Court in February. This was the case of Minor Hotel Group and Diamant, which, as some of you may be familiar with, the business at the heart of that case was the Corbett and King Group, who ran a variety of restaurants in London. And the issue in that case was actually the monitor's ability to bring the moratorium to an early end. And so under Section A38, if the monitor thinks rather than determines or assesses that the rescue as a going concern is no longer likely, or that the objective of the rescue has been reached, or if they're unable to carry out their function due to a failure by the directors to provide information, they may terminate it early. But under the insolvency rules, Rule 1A24, the monitor can disregard debts that are likely within 5 days to be paid or compromise with creditor agreement. So in the Minor Hotel case, you have a situation where the companies that were in moratorium were the guarantors of their holding company. There was an offer that was made that would enable the loan to be repaid, but it wasn't a sort of sure thing. It was going to take a little bit of time to obviously get the financing in place, get the contract signed. And it was common ground that if the rescue was likely, the moratorium could be continued. But what happened is the joint monitors decided not to terminate. So the guarantee creditors applied to court for termination under the provisions of Part 1A to apply for court to do so. And what they did, they wanted to appoint administrators because they said they'd lost confidence in the company's management, which is obviously a common ground for creditors trying to get rid of debtor in possession proceedings. It was Justice Norris, and he said a few helpful things in relation to how Part 1A operates and indeed how the monitor is supposed to operate. The first is that the fact that the termination right or obligation uses the word thinks is intended to give a monitor latitude. So the question that actually has to be asked about when you want to challenge a monitor's decision not to terminate is whether their thinking produced a clearly perverse result. In other words, is it a decision that no reasonable monitor could have reached? Was it irrational? We see an import of the Wednesbury unreasonableness principle into the thinking of the monitor. The second question then is, well, what does it mean for a company to be able to pay the presently due pre-moratorium finance obligation? Well, is it the test that we have under the balance sheet insolvency when we're looking at whether a company ought to be wound up? And what the judge said is that it wasn't that. In this case, you had you have to ask the question of, well, what is immediate receipt? Is a matter of commercial judgment for the monitor, and the monitor is allowed considerable latitude in determining what is commercial, but bearing in mind that anything over 5 business days in order for it to be repaid will require specific assessment of how long it's going to take. So we're not looking at the classic winding up test. We're looking at a much more commercial approach, which I think is sensible. It shows that this is a slightly different task than you might see a court carrying. And in this case, what the judge said is that there was actually no immediate prospect of third-party funds being received by the guarantors or even the company itself, that had the benefit of the loan, and nor was there any assets capable of immediate realization. And so in the circumstances, the decision to resist the application to terminate was said to be irrational, and that noting that the offer that was being made to repay these loans had actually, it was still going to be subject to marketing exercise and an open sale. So it really wasn't an immediate repayment. But I think what is interesting is that the court permitted the moratorium to continue, because the court carried out a balancing exercise, said that the harm that would be suffered by the creditors who had applied to terminate would in fact be less than a significant harm to companies if the insolvency proceedings had been commenced following a termination. And actually, by the time of handing down of the judgment, the principal debt was in the process of being repaid. So it looked like everything was going to be fine. So, I mean, looking at that case, what we can take away from it in respect of the moratorium is that monitors are subject to Wednesbury unreasonableness. So commercial considerations will be key. It's a much wider sort of view that can be taken. There is a discretion that remains with the court whether they can terminate, and they're going to probably approach that pragmatically. There's a willingness by the courts to treat the new provisions as a distinct regime that aren't necessarily beholden to similar questions in other areas. So that's the rejection of the cash flow insolvency test. And actually, what's interesting as well, that the judgment looked at the commentary and parliamentary debates that came out as CIGA was being passed and enacted, and noted that the support of financial lenders will be key to the success of the moratorium, and that'll either probably be via waivers or standstill agreements in order to avoid acceleration clauses being deployed to force a termination. And then there has been one other case, much further afield, in the case of Rehydrodec, and that's a decision in Australia, which held that the Part A1 moratorium is a foreign proceeding, but not a main proceeding under the UNCITRAL model law on cross-border insolvency. So we can see that there is some foreign recognition of this procedure, but of course, whether it'll be recognised in Europe, obviously we'll need to see and wait for future cases.
So looking to the future, what might we expect to see? What might make it a more attractive process? And where might we expect more litigation to arise?
So I think the first area where that's probably going to rise up is the fact that there's minimal or no detailed guidance in the Act itself as to how the monitors should exercise their responsibilities. And I think we're going to see that filled in with case law, as we saw with Minor Hotel, which itself is a start, but it's simply that there's obviously, a variety of provisions. It's not a short section of the Insolvency Act. So I think there's definitely scope for further challenges and guidance to be given towards how monitors are supposed to assess the company's chances of rescuability, going concern, termination, some of the other termination reasons, how much non-cooperation from a director requires can there be before a monitor pulls the plug, etc. I think as well the time limits, as I noted, were quite short, and I think we all have experience dealing with corporate rescue proposals that they take a lot of time, right? They're serious time and effort, and invariably there are hiccups. So whether 20 days is sufficient to pull together everything you need to get a company rescued, to conclude negotiations, is probably ambitious. I know that's extendable to 40 days, but I think what we're going to see is companies that will need to either seek creditor consent or more likely apply to court to ask the court to exercise its discretion. And its discretion is totally unclear at the moment. There are some threshold requirements that are required to be met before the company will entertain such an application. The directors will have to give a variety of information, including as to the prospects of rescuability, and the court has to weigh the interests of pre-moratorium creditors with the likelihood of arrest. But outside those short statutory provisions, guidance is limited. So we'd expect the courts to help fill in those gaps. And again, on top of that, the English insolvency regime is data-driven. As you set out in your introduction, the University of Wolverhampton is carrying out its evidence-based review. We can expect formal statutory amendments to act on proposals, such as extending the 20-day period, increasing eligibility rights for companies, or other initiatives to increase take-up. I think what's useful in insolvency perspective, where there are these data-driven procedures to obviously have universities carry out research, is that IPs, law firms, and other stakeholders do have opportunities to get involved. And so I think it's going to be very much key on practitioners engaging with this process, seeking to get involved, feeding back what their experiences are, what they felt are the shortcomings, so that down the line we're more likely to have amendments or other guidance published, which will sort of make this a more attractive process.
So lastly, we come to the final one of the three permanent measures, the ban on ipso facto clauses. Have these had any cause for scrutiny so far?
No, and I think that's largely down to the nature of the permanent measure, and again the general suspensions we saw during the sort of the height of the pandemic. As a definition, an ipso facto clause is a provision in an agreement which permits the agreement's termination due to the occurrence of an insolvency event or process or financial condition. And so under section 233B, what we have is a simple prohibition on the enforcement of such clauses in contracts for the supply of goods and services. So again, we see this as a provision that's limited mostly to trade creditors. And I think there's, again, no scope for personal undertakings from office holders to cover supply contracts that you have under so many other sections in the Insolvency Act. So I think what we're going to see is sort of yet to come in respect to that.
And what might be the future issues that arise in respect of section 233B?
Well, I think there's a few things. The first is there are relief provisions under subsection 5 of section 233B. So that's where someone with the benefit of one of these clauses can apply to prevent the stay on enforcement if it causes them hardship. And there's a variety of ways of doing that. An office holder can consent to it. So we might have questions about whether that consent can be unreasonably withheld, the impact of ex parte James, and the duties of office holders. There can be company consent to the operation of these clauses, such as in a moratorium or where there's a voluntary arrangement. And then there's I think the big one, which is the hardship provision. So what might we need to see for a company to show that it's suffering hardship? We might see courts deciding that there needs to be accounting information showing how it might impact other contracts or third parties, indeed the risk of contagion if they're not allowed to get out of this contract, whether that could knock on to them and not have wider knock-ons into economy or other creditors. So it might be that we see the possibility of a coronavirus style test emerging. So comparing the financial position of the creditor with or without the termination being permitted. What else we might see, I think, is attempted workaround. So the provisions of section 233B are quite widely drafted because subsection 3 encompasses not only termination on the occurrence of an insolvency event, but also any other thing which would take place alongside that. So that's, I think, an attempt by the statutory drafters to narrow down the escape routes for clever drafters. But I still think that it's going to be inevitable that there will be attempts to circumvent this. So I think one possibility we might see is arbitrage between the widely drafted ban on insolvency triggers and the simple stay on exercising the right to terminate because of events arising before the insolvency period. So that pre-period stay, it doesn't extend to the any other thing that we see under subsection 3. So I think a creative piece of drafting could use that to its advantage to put a supplier in a better position in the event of a subsequent insolvency. But that's unknown. I think it'll be very sort of fact sensitive to whatever contract it is. But certainly I think that's going to be, I think, where we see quite a bit of litigation in relation to this ipso facto clause ban.
Thank you very much, James. Well, I think we've got just a few minutes for questions, and there are some questions that we've got. So one question is that given that in many SME businesses, there's a simple debt structure with secured preferential and unsecured creditors and no need for detailed valuation evidence, simply the estimated outcome for creditors in the relevant alternative, which is likely to be administration or liquidation. Would the panel not agree that costs would be significantly less if a court application I think that means were not needed? SMEs can use the case law already in place to negotiate with creditors against the possibility of cross-class cram-down. And this is from Alison Goldthorpe. She says, this is my experience in driving consensual solutions at the moment, given the reluctance of creditors to enforce. Then says, in Germany, it is SMEs using the new scheme there, and it's the same in India. So there's no reason why SMEs can't use Part 26A in the same way that CVAs are open to all companies. Does the panel agree?
Well, I can address that question, Tina. I agree that there's no reason in theory why the plans can't be open to SMEs. Of course, we've seen that with the Re-Amicus case. That was a success story. I think really the difficulty here is not just the fact that these hearings are costly, but also the perception of those costs. So that's why I say it's difficult to see, certainly in the short to medium term, plans becoming more commonplace due to the expense. But if the expense can be addressed, there's no reason why they would not be open to SMEs, certainly within those circumstances where an application isn't needed. And then the difficulty with seeing them as certainly as an immediate option, alternative option to CVAs, is obviously that the costs in plans are very much front loaded. I think that is going to disincentivize a lot of SMEs from using the procedure. With plans, obviously, you have to prepare for the 2 hearings, whereas with the CVA, you just have, you implement the plan and then the court supervision comes later. So I think that is something that really is disincentivizing uptake. I agree with you. I've also heard a lot about how the cram down provisions are assisting negotiations in the market. So hopefully that will assist. And so far as the financial information is concerned, certainly if we have a case where it's fairly straightforward and an estimated outcome statement or something akin to that is simply required, then of course it's going to be less costly. I'd flag that certainly in the judicial commentary at the moment, there is a tension between the courts emphasising that there needs to be greater transparency for the members and creditors affected, so they know what issues they need to address, against obviously the identification of the cost issues. So that will need to be borne out, I think, in some more contested hearings, and certainly in the context of SME cases. So I do agree with the position that if we have a straightforward case with no application, then yes, of course, it's going to be more open to SMEs. But I think the target at the moment needs to be addressing not only the costs that are incurred in these procedures, but also the perception, because I think that's what's disincentivizing the uptake.
Thank you, Katie. I think also what might be quite interesting is whether in those straightforward cases, it can do without a court procedure at all. I think that may be sort of also the question. And to address them in a similar way to a CVA. And I suppose sort of like in theory, that actually would be quite good. And then you leave it to a creditor to complain, for example, if the classes have not been put in an appropriate way because you've tried to get the plan approved, a bit like a CVA, yes, so you could do with it that way. I think the difficulty is going to be as to where are the parameters, how you define in the legislation, well, what is the sort of company that this is actually going to affect? So when you define SME, are you then going to define it in terms of, well, if your turnover is less than X pounds per year, and then you would have to define and say, well, if you only have these sorts of creditors and you don't need valuation evidence, then to do that. So I think it may be more on working out what the parameters will be. But I think it's quite an attractive option, because obviously it's worked for CVAs, and then you leave it to a disgruntled creditor to say, well, then to challenge. Otherwise, so in that way, then it would mean that the costs, although they're going to be backloaded, if there is a challenge, it may mean in very straightforward cases where you need to get something through quite quickly, and where you do have simple cases, that you're going to get many more Part 26 restructurings approved out of court. So I think it's going to depend on, like they did with administrations, how much the court believes that it actually should have a hands-on process to actually see the process through, or how much as a matter of policy that process could be taken out of court and just left to, and maybe it would be that you would have to have an IP that actually manages the process properly, as opposed to where you can now have, because it goes through the court process, you can have a non-IP that actually, in effect, monitors the process. Right, so going on with questions. So we've got here, we see who's is a current true SME restructuring plan going through the courts, even notwithstanding a desire to make restructuring plans accessible to SMEs. It's clear from who's that the restructuring plan requires judges to be more activist, even where creditors, and in that case, HMRC in particular, are not present. In order to ensure that these are used properly, valuation in particular can be a costly ground. Do you think, on balance, and noting what you say about future efficiencies, we will simply see more pre-packs in the SME space? Who wants to answer that one?
I can take that question again. My answer to that will be perhaps. I think there's potentially three avenues. We might see more uptake with pre-packs. We might see a consistent use of CVAs, or in light of what we've just discussed in response to Alison's question, as we become more familiar with these proceedings, and so far as SMEs are able to put forward plans that are straightforward, then we may see an increase in the plans. But again, that's going to be subject to us addressing the issue of expense. And I'd also just flag that, as we know generally from litigation, that it's, the revenue of a company isn't always going to be the greatest indicator of how complex the evidence that needs to be considered will be. So it's difficult to future gaze in regards to that one. I'd say maybe.
Okay.
Also probably, I was just going to add,
sorry, James.
There's also an element of it's new, and I think the more decisions we have, the more guidance and clarity, the more I think that the courts will help guide IPs into helping them, craft sort of quicker, cheaper, because they'll know what they need to do. They know how to sort of see off challenges. They'll know how to sort of divide up the classes a bit better. So it's one of these things that it's probably the big Rolls Royce ones will happen now. And then as we get sort of into the medium term, long term, it becomes more sort of accessible, because you'll know what you need to do and what you need to show, and be able to sort of hopefully do that quicker and as it easier yourself.
Just want to thank you all very, very much for attending.